Welcome, everyone. Welcome and thank you for coming. I'm Jacob Levy, coordinator of the research group on constitutional studies, and thank you for coming to the third in this year's research group on constitutional studies lecture series. The lecture series, supported by a generous gift to McGill from the Aurea Foundation, supports bringing leading researchers from the social sciences, philosophy, law, and history to McGill for interdisciplinary presentations accessible to a broad student audience on the values, institutions, and principles of a free society, seeking to make accessible the work that they've done in their research and therefore introduce students to the results of what can be done and what can be learned from research in those areas. RGCS brings together faculty, postdoctoral fellows, graduate students, and an undergraduate student fellowship, primarily in political theory, political science, and political philosophy, but also in law and other areas of the social sciences, for a variety of kinds of research and learning in those same kinds of areas, trying to show the links and connections between normative and empirical work, between them and jurisprudential and historical work, on the structures and foundations of how societies are governed normatively and institutionally, and on the connections between those institutions and foundations and the kinds of societies over which the governing institutions are set. RGCS, in turn, is part of the newly established Yan P. Lin Center for the Study of Freedom and Global Orders in the Ancient and Modern Worlds, a center that is going to bring together a variety of kinds of research groups, all oriented around normative and historical inquiry into social change, social processes, and social formations in fields ranging from political theory to classics to architecture to modern history. The RGCS lecture series will continue next semester with a talk on February 6th by Jenna Bednar of the University of Michigan, one of the world's leading scholars of federalism, and then later in the spring by a year-end debate between Cecile Fabre of Oxford and Eric Mack of Tulane on the nature of property and ownership. Now, one of the ideas that has been central to RGCS since we came together in our current form was the idea of constitutional politics as an organizing theme, something that was not only confined to the study of constitutional law within law schools, though certainly having strong connections to that, and that was not narrowly restricted to normative political theoretical work about what constitutions should be, but rather, and spanning those, work that includes empirical political science about constitutional level institutions, including federalism, judicial review, and the separation of powers. In light of that, it is a very special privilege for us to be able to welcome today's speaker and to welcome him back to McGill. Philippe Lagassé is Associate Professor of Public and International Affairs at the University of Ottawa. He holds a bachelor's in philosophy from McGill, a master's from the Royal War College, and a PhD from Carleton. He teaches in political theory, military affairs, and defense policy. And his research focuses on Canadian defense policy and procurement, civil-military relations and machineries of government, and relations between Parliament and the executive in the Westminster parliamentary system. His work on these subjects has allowed him to serve as a consultant for government, political parties, and the private sector. He regularly comments on defense affairs and on the Westminster system in the media, and is a member of the Independent Review Panel for Defense Acquisitions by the Governor of Council. He's co-author of Reviving Realism in the Canadian Defense Debate, and co-editor of The Crown and Parliament, and Canada and the Crown, the two, I think, leading collections on the themes and topics that he's going to be talking about with us this evening on the Crown and the Monarchy in the Canadian Constitution. Please join me in welcoming Philippe Lagassé.
Well, first, I'd like to thank Professor Levy for inviting me here tonight, and to thank you all for attending. As Professor Levy noted, I did my bachelor's degree in philosophy here at McGill, and the last time I was in this building, Thompson Hall, I was taking a fourth-year graduate seminar with Professor Philip Buckley from the philosophy department on Heidegger and technology. And while the topic that I'm going to be addressing today is somewhat less complex metaphysically, hopefully it'll still be entertaining and perhaps eye-opening on some level. So the question I'd like to address in tonight's lecture, how have the courts in Canada interpreted Canada's constitutional monarchy since 1982? And a sub-question, how have these judicial interpretations shaped the Crown in the Canadian Constitution since that time? Now, in adapting my approach to this, it is an interpretive investigation, one that combines two theories, and I'd like to just lay them out here in order to make sure that my epistemological approach is well understood, and as well to try and get a sense of what I mean by the judiciary and institutional change. So the first point to make here is I'm not going to be offering a legal analysis as to the veracity of what the courts have found. On the contrary, what I'm trying to do is actually understand how the courts have actually interpreted this particular aspect of the Constitution. And in using Lawton's interpretive approach to public law, what I'm trying to do is see how their understanding of the Crown shapes their understanding of the Canadian state, or vice versa. That is, how do the courts understand the state in Canada, how do they understand the Constitution in Canada, and how does that therefore inform their understanding of this particular aspect of the Constitution? So using Lawton's basic idea, if we understand judicial interpretation not as a matter of an objective understanding of the law, but rather as a reflection of political theoretical presuppositions, then my attempt here is to try and get a sense of how the courts have understood the Canadian state vis-a-vis their engagement with the Crown. Or, to put it somewhat differently, how have they not understood the Canadian state through their engagement with the Crown? The second approach that I'm doing in order to frame this a little bit more concretely is the work of Mahoney and Phelan on their theory of gradual institutional change. Now, those of you that may be familiar with the political science literature on institutions, it's divided in quite a wide variety of institutional approaches. But one of the most powerful ones in the past was something that was called historical institutionalism. And historical institutionalism presupposed that there was a certain degree of path dependency in how institutions evolved. And the basic idea is once a historical conflict or battle over the nature of an institution is settled, that institution will likely continue upon that course in spite of whatever pressures it might face, unless there is a massive exogenous or endogenous, external or internal change that will force people to shift their approach to that institution. Now, Mahoney and Phelan for many years were historical institutionalists that very much bought into the idea of path dependency when it came to institutions. However, they eventually realized that institutions do change, but they don't change quickly, they change gradually. And therefore, if we're going to have a better understanding of how institutions actually evolve over time, we have to develop a theory of change of institutions. And so their theory of gradual institutional change stresses the fact that change agents will attempt to bring about various types of change depending on the types of veto that they face from other actors. So simply put, different types of change will occur depending on the motives of a change actor or a change agent, and how much difficulty they have in bringing about that change. Now, the particular agent, change agent, that I want to focus on today, as I said, is the judiciary. The judiciary as the arbiter and interpreter of law and how that shapes institutions. Now, this isn't to say necessarily that the judiciary is a partisan political actor by any means, but I am presupposing that the judiciary is a political actor in the sense that it is involved in institutional change. And therefore, if we want to understand institutional change in Canada and the role of the courts, we have to understand that the courts are change agents to some degree, and they are therefore inherently political, and not simply, again, with reference to Lawton's theory, not simply involved in an objective reading of the law, but quite on the contrary, they are involved in their interpretation of the law in institutional change. Now, this is particularly pertinent when we're looking at the Crown and the courts, because whereas in the United Kingdom, Parliament has really been the main force and the main actor behind changes to the Crown over time. And we can see a variety of examples of this. Just the 2010 major constitutional reforms, for instance, that we saw in the UK recently, where the Queen's prerogative to dissolve Parliament was effectively removed by Parliament, as one good example. We don't see that type of change in a Canadian context between Parliament and the Crown. The Crown has actually been, or the Parliament I should say, has been quite reticent about engaging with the Crown and very rarely attempts to encroach upon the Crown's powers or its prerogatives. Part of this, as we'll see in the presentation, is a reflection of the fact that for most of Canada's history, Parliament did not actually have the power to affect the Crown because the law that upheld the Crown, or the law that made the Crown's powers pertinent, was a British law. And therefore Parliament wasn't actually engaged with the Crown. And as a result, in Canada, it has been the courts that have been primarily the ones engaging with the monarchy, with the Crown, and have therefore been shaping it. First, through the Judicial Committee of the Privy Council, and then later, and subsequently, Canadian courts and the Supreme Court in Canada. So there's actually a fairly rich history between these two institutional actors in Canada. And it should be noted, just for the sake of irony, that the courts, even though they shape the Crown in Canada, are still technically, constitutionally, Her Majesty's courts. What is my argument? My basic argument is that since the Constitution Act of 1982, the courts have allowed the Canadian Crown to drift. Now, what do I mean by drift? Going back to the theory of institutional change that I mentioned, drift, according to Hacker and Mahoney and Thalen, occurs when the rules remain formally the same, but their impact changes as a result of shifts in internal conditions. And so this type of change occurs when actors choose not to respond to environmental changes, and their very inaction leads to changes on the institution. So it drifts because you effectively have there is an institution that's in place, a change occurs in your external environment around that institution, but actors, for a variety of reasons, simply don't bring the institution up to date, and therefore it ends up drifting. Its relevance begins to wane, or it actually is used in different ways. And so the reason I'm saying that the courts have adopted this particular approach is that while they have reinforced the Crown as the executive power and the structure of government administration in Canada, the court's understanding of the Crown as the source of sovereign authority in Canada and as the concept of the Canadian state never kept pace with the patriation of the Constitution in Canada. So simply put, because the Crown is the concept of the state, because it is the concept that we still have of sovereign authority, that means ultimately that were you to achieve full independence in 1982, then you should have as well updated your concept of the Crown to keep pace with that change, to actually make it a Canadian crown as opposed to a British crown. But the courts haven't done that. And what's the result been? The result has been that Canada actually remains without a coherent concept of the state, and in spite of the fact that we insist that we are fully independent from the United Kingdom, constitutionally, at least as far as the courts have told us, we are not fully independent of the United Kingdom. So this creates a bit of a drift situation, where you should have updated the Crown, and as I'll explain, Australia and New Zealand did, we did not. And what are the ramifications of that going to be? So, what I'd like to do is begin with a discussion of the legal evolution of the Crown and the British tradition to kind of flush out these concepts of the Crown as of the state and of the source of sovereign authority, discuss the evolution of the Crown up until 1982, discuss the impact of the Canada Act and the Constitution Act, and then look at my particular case. So in three areas: the executive, the meaning of the Queen, and the two cases that are really bringing this to the fore today, oaths and royal succession. All right, so let's get into the metaphysics. So, the evolution of the crown as a concept. So, in post-conquest England, the crown ultimately was a personal thing, and it was a personal concept. And the feudal system of the time in post-conquest England focused on the personal powers of the monarch as a natural person, and as a person, and as of their personal relationships. Power was personal. Therefore, there would have been no differentiation between the person of the monarch and the authority that that monarchy wielded. And similarly, the power of that person's pronouncements and the power of law that that person's pronouncements had would not have been differentiated from who that person was as an individual. It was a personal state, as it were. The state was the monarch in a real personal sense. Very early on, therefore, this led to an equivalence in law between the sovereign as a person and the concept of the crown, their legal authority. Therefore, the sovereign and the crown were one as early as the 12th or 13th century. These concepts were fused. Now, this created difficulty over time, however, because as you start to develop a more modern and complex state, you need to actually develop a theory of the state. So how did they go about doing this? Well, those of you that are familiar with the book, The King's Two Bodies, will know this pretty well. British, or I should say English, legal authorities at the time effectively used a concept that existed in the Catholic Church, namely the idea of a corporation soul. That is, bishops at the time, in order to ensure that every time a bishop died, there would be an automatic succession to another bishop, and that bishop's property would still be held, created the concept of a person as a corporation. So in this corporation, the bishop never dies. The bishop is always there. The bishop always holds the property. So even though you might have Ted be the bishop one day, and Jerry the bishop the next day, it's still actually the same bishop in law. Hence, when you apply this concept to the crown, what they were able to do was ultimately develop an undying king, a king that would never die in a perpetual crown. So it's always the same person. The crown and the monarch are always the same, therefore there's no need to redevelop contracts that were made by the person, no need to restate that the monarch owns property in particular ways, no need to re-establish military service or contracts on that level. The state became the personified state, but even more fundamentally, became a legal personality. So sovereign authority was not simply vested in a person, but it became vested in a fictional person, a legal personality, a persona ficta. Now, this was most interestingly confirmed by Edward Coke in Calvin's case, where he affirmed that, interestingly, Calvin, who was a Scot, had sworn allegiance to James I as King of Scotland. And then when James VI at the time, I should say, of Scotland, when he became James I of England, Calvin wanted to be able to own property in England, and it was decided that his oath to James VI was also an oath to James I, and therefore the situation was reconciled. So through the concept of the corporation soul, you were able to get around a lot of these sticky issues of the nature of sovereignty and the state in the British Isles. But it was still a very highly religious concept. It's only when Hobbes finally came around, and I find this particularly amusing in the Hobbesian case, because although Hobbes writes quite a bit about the schoolmen and the scholastics, he's very happy to borrow as many scholastic concepts as he feels necessary to get his point across. So Hobbes creates the artificial man, the Leviathan, which is effectively just a corporation soul. So he goes and borrows the idea of the artificial man to create his state. And that theory of the state as the artificial person, the artificial man, is therefore begins as a theological concept, becomes a political one, and then becomes the concept of the modern state in the British system. And after the Glorious Revolution, which those of you who are well versed in these issues, the UK never really has its full Republican revolution that fully changes the nature of its legal system and of the state, and therefore the Glorious Revolution retains the crown as the concept of the state, even though sovereignty ultimately is vested in the crown and Parliament. Very quickly, going over the British debate about this, since it is interesting. Very good book by Janet McLean, 2012, Searching for the State in British Legal Thought, posits this as a debate between Blackstone and Bentham. And Blackstone embraces the corporation soul and embraces the idea of the state as a person, embraces monarchy as the underlying principle of British sovereign authority. And therefore, Blackstone is more than willing to engage with the idea of fictions as underlying the British and common law legal tradition. The state for Blackstone ultimately is the Crown as a corporation. Bentham, on the other hand, wants real people with real powers, and therefore is much more focused on who's actually doing what, as opposed to the fictions behind it. And over time in the British debate, this has gone back and forth. Those of you that are familiar with Maitland's critique of the Crown as corporation soul, where he says, the problem with the king is that the king was parsonified, made to be a parson, and that this simply makes no sense. As opposed to trying to maintain the Crown as, or maintain the British state, that is, as a single person vested with almost divine authorities, Maitland says, why not make the Crown a corporation aggregate? So make it like a corporation like others. You can have corporate entity, you can have a legal personality, but as opposed to trying to make the monarch something else, why don't we simply make the monarch the head of this larger corporation? It would solve many of our problems. The British interaction with this, however, has gone back and forth. In Town Investments, the courts in the UK seem to embrace the idea of the Crown as a corporation aggregate, whereby the state is this larger corporation with the monarch simply at its head. However, whenever the issue comes up of state immunity, or whenever the courts need to deal with a particularly difficult situation where it wants to protect ministers, or it wants to protect certain agents of the state from legal action, it is more than willing to fall back on the concept of a corporation soul that protects the state from legal action. And therefore, this concept has not quite died in the British debate, hence Maclean's book. Another interesting area of debate in the UK, and I'll just mention it here because it's one area where we really differ from the UK, is what's called the Ram Doctrine. Now, in the Ram Doctrine, this general idea is that if the state in the UK is a legal person, then that state has all the powers of a person, of a natural person, which means effectively, in common law, that the state can do anything that the law doesn't forbid. Now, this is a vast expansion in some case of executive authority and state authority. And UK scholars have for many years been trying to dig at this Ram Doctrine and expunge it from British constitutional practice. We, on the other hand, as I'll mention, embrace it and love it and use it all the time. And it's just taken as a given in Canada. It's quite interesting that they seem to care quite a bit more about this than we do. The debate over the Crown in the UK, however, is now going off in a different direction over the past 20 years. Effectively, while these issues of what kind of corporation it happens to be linger, and questions about the Ram Doctrine and others are still pertinent, the British debate over the nature of the Crown is effectively one where the Crown is now being marginalized, pushed to the very outer limits of the Constitution, and is no longer really of any significant importance. And if you're the betting type, which I'm not, I'm the pessimist type, but I basically look out at it and say, in all likelihood, Britain will have a Swedish monarchy, or Swedish-style monarchy within the next 20 years, where the Queen is simply there and exercises, or the King as it happens to be, no real powers of any significance. Which is, again, quite interesting from the perspective of the realms, such as Canada or Australia, where the Crown and the Queen is actually going to have far more power in former colonies than he or she will have in the UK. Now, what about in Canada? Where has this led us? And what does it mean for us? As all of you know, I hope, in the British North America Act, Canada is a dominion united under the Crown of the Great Britain and Ireland. Now, I would just quickly note here that the United Kingdom of Great Britain and Ireland actually no longer exists. Does anybody know what we have now? Yeah, it's actually an important point, right? It's if we're to refer to this, it's the United Kingdom, but it's no longer quite the same United Kingdom. So it is now the United Kingdom of Great Britain and Northern Ireland, but at the time it was the Crown of the United Kingdom of Great Britain and Ireland. So this effectively meant, and it makes perfect sense at the time, the British North America Act being a law of the British Parliament, that Canada was founded as a dominion under the sovereignty of the British Crown and Parliament. And at the time, it made perfect sense. It was an indivisible imperial crown. And there was no question that the imperial parliament held absolute authority over Canada in matters of law and also in matters of executive authority. So for instance, another area that I work on quite a bit is Section 15, Commander-in-Chief. Now, why would it be necessary to reiterate in 1867 that the Queen retains the powers of Command-in-Chief in Canada? Well, because you're an indivisible imperial crown, you don't want your colony creating armed forces that will go off and do their own thing. You want to ensure that in times of war, any armed forces that are raised in Canada belong to the Crown. The Crown can do whatever they want or need with them. This is an important concept that you want to maintain within that constitutional construct. So there is no question in 1867 that Canada is created as an emanation of the British Crown and is under the sovereign authority of that Crown. This is not particularly practical over time, however. Gradually, the Crown becomes divisible through usage and practice. What do we mean by this? Well, over time, it is decided that we can treat the crowns as separate when the Crown is advised by different ministers. So when the Crown is being advised by Canadian ministers, then it is effectively the Crown acting for Canada. When the Crown is being advised by British ministers, then it's a British Crown. And this becomes very useful in Canada. Why? Because we have provinces. And this makes all the world of difference. Therefore, you can explain why you might have a situation where the Crown being advised by her ministers in Quebec would be a separate legal entity than the Crown being advised by her ministers at the federal government. And it allows all sorts of different things to occur, which are quite useful in a federation. Namely, provinces can sue one another. Provinces can enter into agreements with one another, even though they are all the Queen. So you need to make sense of this. And although the concept of corporation sole strikes us as absolutely archaic and bizarre, it's actually quite useful to be able to say that there is a legal personality called Quebec, or Her Majesty in Right of Quebec, that may choose to sue Her Majesty in Right of Canada. And even though there is only one Majesty and one Queen, it's just simply practical to be able to say that there are two legal personalities that are involved with one another. And so, this medieval concept allows the Queen, in one aspect of her capacity, and her capacity as Queen of Quebec, to own property in Quebec, also own property at the federal level, to enter into contracts with herself, depending on where she is, and therefore the multitude of different legal personalities that clarifies relationships of federalism in Canada at a time when we're still using a concept that was developed in a unitary state. But it ends up being quite useful. And although there is resistance to this idea in Canada, and I'll cite Bora Laskin in particular, in 1969, his book on the British tradition or in Canadian legal thought, Laskin makes the point quite aggressively that the Queen, or references to Her Majesty in Canadian law, is simply an anachronism. We don't need it. It makes no sense that we're retaining this. And yet, it proves very useful. Because he says, quite clearly, well, you could simply have a situation where instead of saying Her Majesty in Right of Canada, you say Canada. Or you could simply say, instead of Her Majesty in Right of Quebec or Ontario, Ontario and Quebec. Ah, very true, Bora. But what do you do when you want Quebec or Ontario to contract, or to employ, or to do all these other things? Very naturally, you have recourse to the legal personality, because you have yet to define in law what these things actually are. And so, we end up even with some of our foundational laws, I would say, about how we interact with the state. And I'll note the main one that I find fascinating, the Crown Liabilities and Proceedings Act, If you go look on it today, it still tells you, and the French translation is always useful. It's always good to be able to look at the translation in Canada, another bonus that we have, because it kind of clarifies things exactly what you're saying. What is l'État in the Crown Liabilities and Proceedings Act? Her Majesty. So we retain a concept of the state in Quebec, but ultimately it means the legal personality of the Queen. So it may be an anachronism, but it is a very useful anachronism. Where it gets stickier is the development of a uniquely Canadian crown. One of the pivotal moments in the development of a unique Canadian crown happens in 1893. And at this juncture, Section 2 of the B&A Act read, "The provisions of this Act referring to Her Majesty the Queen also extend to their heirs and successors of Her Majesty, Kings and Queens of the United Kingdom of Great Britain and Ireland." So this would have been a very useful section. It would have clarified exactly who you're referring to in all cases when you're referring to the Queen. But for some reason, in 1863, law clerks in the UK decided to repeal it. Now there's a great deal of debate about this. Why would they have done this? Why did they repeal Section 2? Now, just a few days ago, it was announced that Mark Walters is joining your faculty, and one of the great scholars of the Canadian Constitution. His argument is, in my edited book on the Crown and Parliament, that this section was simply deleted by mistake. They didn't know, well, you know, they meant to delete something else. They weren't quite sure what they were doing. Careless clerks, he calls them. Maybe, it's quite possible. It's quite possible that they simply deleted it by mistake. Others, such as my friend Thomas Hall, former law clerk at the House of Commons, makes the argument that, in fact, we didn't even know that Section 2 was repealed up until the mid-70s, when we suddenly discovered it was repealed. And therefore, we should really, you know, we had no say in this. Let's just assume that it's still in force. Which I find, it's a mind-boggling argument. It's a great argument. And I'm no lawyer, but if you tell me that an act has been repealed, but that we should just assume that it's still there, I don't know, but there might be a problem. We'll see. This will all be settled soon. I know I'm wrong, but, you know, it's fun to question the logic of it. So, this act is repealed in 1893, so we have a difficulty. Who is this Queen to whom we refer? We start getting answers quickly. The Balfour Declaration of 1926 at the Imperial Conference gives Canada foreign policy independence. By extension, it means that Canada effectively has executive power independence, because executive power is what's needed for foreign policy power. The Statute of Westminster of 1931 grants Canada legislative independence. From this moment forward, the UK Parliament can only legislate for Canada upon the request and consent of the Canadian government. Now, nobody thought much about this until the Abdication Act of 1936. Now, in this situation, King Edward, wants to marry a divorced woman. This becomes quite the scandal. Therefore, the UK cabinet consults with the Dominions and asks them, what do you think? Should he be able to marry Wallis? And the general opinion is that no, Edward should not be able to marry Wallis. Therefore, give him the advice that he must either abdicate or marry. So, Edward chooses to marry Wallis regardless, and therefore must abdicate. This occurs at a time in December 1936 when the Canadian Parliament is not sitting. And therefore the Canadian Parliament is not in a position, as is outlined in the Statute of Westminster, to simply assent to the British Act. And there's a big debate. Again, the entire royal succession case that's happening in Quebec today is ultimately revolving around this precedent. The Canadian government at the time says, and this may simply be because Mackenzie King is an ardent nationalist and therefore wants Canada to be recognized as an independent state, but he says no, it is simply not the case that whoever is the Queen of the United Kingdom is the Queen or the King of Canada. We have to make a legal change because we have a separate line of succession. It is not the case that we have an automatic recognition that whoever is the Queen in the UK is the Queen or King of Canada. And therefore, in December 1936, the Canadian Cabinet requests and consents for the Abdication Act in the UK to extend to Canada, effectively creating the idea that if you're going to change the Crown in Canada, you need an actual law. Incidentally, the Abdication Act also includes the Act of Settlement and makes changes to the Acts of Settlement, which may indicate that the Act of Settlement is actually part of the Canadian Constitution. This keeps going. Declaration of War, 1939. One of the most important acts of state that one can make. War is declared for the UK a full week before it is declared for Canada. During that time, the United States uses this opportunity to treat Canada as a non-belligerent, bringing in supplies and other things that go to the UK. Now, in law, is Canada an independent state, or is Canada automatically at war? It is only if you have a concept of an independent crown, or at least a crown acting only for Canada, that you could entertain the idea that Canada is not automatically at war when the UK is at war on the 1st of September. There again, another step is taken. In 1953, the title of Queen of Canada is bestowed upon Elizabeth, or added to the royal styles and titles. At the time, Prime Minister Saint Laurent says, no, don't worry, it's not a separate office, still the same person, we're not changing anything, but effectively this now has been added, Queen of Canada as a concept. In the 1970s, just to cap it all off, Australia and New Zealand begin their march towards full independence, and one of the things they do is bring in imperial acts legislation, which means basically all the acts of the British Parliament that used to apply to them is actually brought into their legal system. We think about doing this, but we get sidetracked by something called the Charter of Rights and Freedoms. It's funny how that works. Luckily, the British courts are there to save us. The Alberta Indians case makes clear a couple things about the nature of the Crown in Canada. Although I should note that this is British jurisprudence and therefore may not apply in Canada, which is actually pertinent to what I'll get to next. But the British law lords make a number of interesting points. At issue here is the case by various First Nations groups saying that the British Crown ultimately has treaty obligations towards them. Now you can understand the trepidation that this might cause in the House of Lords. So the House of Lords says, well, no, that's not actually the case. In matters of law and government, the Queen of the United Kingdom is entirely independent and distinct from the Queen of Canada. Lord Kerr, Her Majesty is the personal sovereign of the people inhabiting many of the territories within the Commonwealth. All rights and obligations of the Crown, other than those concerning the Queen in her personal capacity, so again referring back to the Queen as a corporation sole, not her legal capacity, but her personal capacity, can only arise in relation to a particular government within those territories. So, Lord May, and this is interesting, as a matter of construction, the Statute of Westminster did retain a limited sovereignty of the Crown and the right of the United Kingdom over the Dominions. But, as Lord Denning says, the Canada Bill is designed to give complete independence to Canada. Unfortunately, did that actually happen? The Canada Act 1982 and the Constitution Act 1982. Changes to the Statute of Westminster are probably the most important. Namely, the UK Parliament can no longer legislate for Canada, even on the request and consent of the Canadian government. Quite significant. We can no longer rely, in principle, on the UK to make changes to the Canadian Constitution. Now, it also gives us, as I said, the Charter of Rights and Freedoms. Why is this important for the future of the monarchy? Well, it creates a whole new means of actually challenging the monarchy in Canada. And the cases that we're now going to be dealing with, look at that. The Charter allows you to challenge prerogative authority, executive power more effectively, and it actually allows you to subject aspects of the monarchy that would never have been allowed in the past to be challenged in courts, namely oaths to the Queen and royal succession. The amending formula also adds in paragraph 41A the concept of the office of the Queen. The Governor General and the Lieutenant Governor of Province can only be altered by unanimous constitutional amendment. However, there's a number of aspects of the Canada Act that leave ambiguity about the nature of the Crown in Canada. The schedule to the Constitution does not include any of the imperial acts that Australia and New Zealand chose to bring in. So the applicability of those acts to Canada is unclear. We do not know, for instance, if the Abdication Act of 1936 applies to Canada or is part of the Constitution of Canada. We don't know if the Royal Marriages Act is part of the Constitution of Canada. We don't know if the Act of Settlement as a full matter of law is. We know that certain principles of the Act of Settlement are part of the Constitution of Canada, but we don't actually know if the Act itself is. Now, during the lead-up to the patriation of the Constitution, there's a particular confrontation, or I shouldn't say confrontation, but an exchange, as it were, between then MP Serge Royal and Justice Minister Jean Chrétien about the schedule. And Royal asks Chrétien, "It seems to me that the schedule is rather limited. It doesn't include all these various acts. Why is that?" Chrétien says, "Well, you don't need to worry about it. The schedule, it clearly states that it includes this. It doesn't exclude anything. So it's very possible that all these other acts are part of it. You don't have to worry. It'll all be enumerated. We'll figure it out in the future." So there we go. It could be there. It might not be there. We don't know. We have no idea if the Crown is, all the acts pertaining to the Crown are actually part of the Constitution of Canada. They just didn't consider it all that important. If you listen to the renowned scholar of constitutional conventions, Andrew Hurd, he will say, clearly the intent was not to remove the Britishness of the Crown at this time. Because if you look, for instance, at Section 57 of the 1867 Act, it still refers to the Queen and Council as separate from the Governor and Council of Canada, which tends to imply that the British Cabinet still has some power over Canada by virtue of the fact that the Queen is still treated as a British entity. Similarly, the Oath of Allegiance still refers to the Queen of the United Kingdom. And therefore, there are a number of aspects of the BNA Act or the Constitution Act 1867 which are not amended in 1982, which may give us the impression that maybe their intention was still to leave a British head of state for Canada or a British state. But we simply don't know because there are too many other contradictory pieces of information. I think it's worthwhile here just to have a little bit of a sense of how people reacted to the Constitution Act 1982. And this will tell us, where the debate went after. And I'm going to juxtapose two different opinions that came out shortly thereafter to give you a sense of how the Canada Act was interpreted. The Law Reform Commission of Canada, working paper number 40, quite clearly stated that the Constitution Act had actually not changed the nature of the Canadian state at all. The Crown remains the legal personality of the executive and the state. It clearly states, for instance, that the Crown is involved in all aspects of the state. The Law Reform Commission goes so far as to claim that the Crown remains imperium in Canada. Public authority, puissance publique. As a result of that, the Law Reform Commission says we must reform this institution because it provides too much immunity to public bodies, to the executive, to Crown corporations, to ministers. What we should do is simply reduce the Queen to head of state and get rid of the Crown as our concept of the executive and the state because it provides too many difficult ways of getting around the law. Berkison and Cooper, however, have a very different interpretation. They say what's happened in 1982 is that we've effectively gotten rid of the Crown as the source of sovereign authority. The people are now sovereign in Canada. The reason we know this is that the Queen has now simply been reduced to an office. It's simply been reduced to one part of the Constitution that can be abolished by any kind of, by unanimous amending formula by the parliaments and the legislatures. Now what I'm going to demonstrate here is that the courts actually go in both directions. They seem to be embracing what the law reform has said, but without quite going as far as the law reform wanted. However, they're also, through drift, effectively embracing Berkson and Cooper's idea of the Crown as merely one aspect of the state and no longer the concept of the state. But the consequence is we have no concept of the state. So, the executive administrative Crown in Canada is reinforced after 1982. Operation Dismantle recognizes prerogative authority retains. The nature of the civil service in Canada is still fundamentally linked to the Crown. Ministers are still fundamentally seen, and the powers ministers have are still monarchical servants, and their powers still flow from it. The RAM doctrine that I mentioned is clearly enunciated as late as last year in Canadian Doctors for Refugee Care versus Attorney General. It is quite clearly stated that ministers can still use the powers of the Crown as a natural person or a legal person to make decisions that the law would seem to forbid. So in matters of administrative law, the Crown's immunities and powers as a corporation soul still matter quite significantly. However, when it comes to the meaning of the Queen, we see drift. In the Senate, or a reference on Senate reform, the Queen and the Crown are no longer the state. They are simply head of state. The Crown has been reduced from the concept of the state to merely one part. Stated in the Senate reference, the British structure of a lower legislative chamber composed of elected representatives, an upper legislative chamber made up of elites appointed by the Crown, and the Crown is head of state. Nowhere is it mentioned that the Crown is the actual state. Similarly, reference re Canada assistance. The Queen is our head of state, so the true executive power lies in Cabinet. So not only is the Crown not the state, the executive is now no longer really the Crown either. Where are we moving towards? A Bentham, real people with real powers, as opposed to the corporation soul. In New Brunswick Broadcasting, Justice McLaughlin, as she was then, even suggested that effectively the Crown, which she limited only to the Governor-General and Lieutenant Governors, forms a distinct branch of government from the executive and legislative branches. So moving along with Bergson's idea that in fact it's now simply an institution of very little meaning. However, what's interesting for our discussion today as well is that it remains a tenaciously British monarch in the view of the Supreme Court. So even immediately after 1982, 1 year after Canada is supposed to have achieved full independence, we have the Supreme Court telling us in Canada, the head of state is Her Majesty the Queen, the reigning monarch of the United Kingdom. Oaths and loyalty to Her Majesty. How have the oaths case transformed our understanding of what the Queen is in Canada? In the first case, Roach versus Canada, we have a situation where the federal court is asked to identify what the oath to the Queen actually signifies. So for those that are unfamiliar with it, I'll just repeat it. I swear or affirm that I will be faithful and bear true allegiance to Her Majesty Queen Elizabeth II, Queen of Canada, her heirs and successors, and that I will faithfully observe the laws of Canada and fulfill my duties as a Canadian citizen. In the federal court case, we are told that it is simply an oath to the Constitution of Canada. So it's an oath to the head of state, and therefore it's actually an oath to the Constitution of Canada and what the Constitution of Canada means. It's not an oath to the Queen of England and as head of the Anglican Church, not because the Queen of Canada is separate from the Queen of the United Kingdom, only because in a Canadian context, she's not the head of the Church. So same Queen still, just not happens to be the Queen acting differently in a Canadian capacity. So although it personalizes the Crown, and in Roach, the federal court still recognizes that Queen Elizabeth is the personification of the Crown in Canada, and therefore the personification of the state, it's still a reduction of the role, and some hint at the fact that this is still fundamentally a British monarch. In Chenig, it goes even further. Chenig is a case where an officer in the Canadian Forces does not want to salute or bear allegiance to the Queen. He therefore brings this case before the courts. He is told by the Canadian Forces that that what he is actually swearing to is Her Majesty Queen Elizabeth II, Queen of Canada. That is what he's told by the Canadian Forces. It is therefore natural, the Canadian Forces tell Chenig, that she is the head of the military and the head of state, she's Queen of Canada. That's why you're swearing allegiance to her. Judge Barnes, however, gives us a different interpretation. It is fundamentally a political and democratic process to change who is head of state in Canadian polity, he says. But the fact remains that our present ties to the British monarchy are constitutionally entrenched, and unless that is changed, it remains loyalty to the British Crown. So although the Canadian forces are making the point that it's actually the Canadian state, the federal court here is saying that it's the British monarch that Chinning is swearing allegiance to. Perhaps my favorite case of recent time is the Ontario Superior Court case of McKeeter versus Attorney General, which attempts to once again challenge the oath to the Queen, but this time in Ontario court. Now, what's particularly interesting about McKeeter at the Superior Court is that the judge is Edward Morgan, and Edward Morgan is a former law professor at U of T, I believe. So he's going to know his stuff, and indeed he does. Morgan says, the Crown sits at the apex of the legal and political system in Canada. Canada, he says, is one of the realms where Her Majesty is sovereign. He says there is no doubt that Her Majesty the Queen is Queen of Canada, the embodiment of the Crown in Canada and the head of state. Her Majesty the Queen and Right of Canada, as a governing institution, has long been distinguished from Elizabeth R. and her predecessors as individual people. He's therefore making allusion, very much so, to the fact that in her legal capacity there is a Queen of Canada. And he goes further. Not only is the Canadian sovereign not foreign, as alleged by the applicants, but the sovereign has come to represent the antithesis of what they were railing against, status privilege. The Canadianization of the Crown, achieved through political and legal institution, the Canada Act, or the Constitution Act 1982, removed the last vestige of British authority over the Canadian Constitution. This is at the Superior Court level. And Morgan seems to be very much affirming that the Crown has actually kept pace with the patriation of the Constitution in 1982. However, when the case goes before the appeals court, we get a different answer. And why is this? Well, I have a little pet theory here. Leonid in the back will maybe correct me on this, but we'll see. My theory is the following. In the Superior Court case, Justice Morgan actually found that there was a violation of the appellant's charter rights, but that it was defendable under Section 1, I believe. Now, the federal government is actually determined to make sure that it is not seen as a violation of charter rights. In the appellate court, Justice Wheeler finds a way out of making it a charter violation. What does she say? She tells us that ultimately the Crown, or the Queen of Canada, does not refer to a person at all. It does not refer to a British monarch because the British monarch lives over there. The Crown in Canada, she basically tells us, for all intents and purposes, I won't bore you with long quotes, is but a symbol. It has no actual meaning. So it's not the question, it's not the personification of the state, it is not the executive power, and the Queen has no ultimate meaning. She says, the oath to the Queen of Canada is an oath to our form of government, as symbolized by the Queen as the apex of our parliamentary system of constitutional monarchy. Although the Queen is a person, in swearing allegiance to the Queen of Canada, the would-be citizen is swearing allegiance to a symbol of our form of government in Canada. This fact is reinforced by the oath's reference to the Queen of Canada instead of the Queen. It is not an oath to a foreign sovereign. So basically, the Queen is a foreign sovereign. The Queen of Canada is simply a symbol for our system of government. So I ask on the slide, we begin with a Canadian Queen, then we have a British Queen, and now we have a meaningless Queen. Royal succession. Two cases. In ODonoghue, we have ODonoghue using the charter to challenge the Act of Settlement of 1701 and its exclusion of Catholics from the succession. In order to get around this, Judge Rouleau in O'Donoghue comes up with quite, if I can put it this way, some fantastical notions about the nature of the Canadian Constitution, many of which are contradictory. So he points to the preamble, which I mentioned earlier, that Canada is united under the Crown of the United Kingdom and of Great Britain and Ireland. He says this portion of the preamble confirms not only that Canada is a constitutional monarchy, but that Canada is still united under the Crown of the United Kingdom of Great Britain, where our monarch is shared with the monarch of the United Kingdom. As far as O'Donoghue is concerned, we are still under the British Crown. The sharing of the British monarch is fundamental to our constitutional framework. We share the crown with the United Kingdom, he says. This is essential. The symmetry and union of Canada under the British Crown, he says, was recognized and adopted in 1937, even though, in actual fact, it was the exact opposite argument that was made in 1937. But he tells us it is absolutely the case. Canada is still under the British Crown. The reason that he tells us all this, he says, is that there is a principle of symmetry. Whoever is the monarch of the United Kingdom is automatically the monarch of Canada, and therefore that rule is not subject to charter challenge. As importantly, he tells us, in order to make this case, the Act of Settlement is part of the Constitution of Canada, he tells us. So to finish, he writes, these rules of successions and the requirement that they be the same of those of Great Britain are necessary to the proper functioning of our constitutional monarchy, and therefore the rules are not subject to charter scrutiny. This same case is taken up in Teske and fails for the same reasons, which brings us to the Succession to the Throne Act. Now, I'm aware I'm running out of time, so I will make it quick. Basically, in the Succession to the Throne Act, the federal government decides that it will adopt O'Donoghue's basic framework to deal with the matter of royal succession. So very quickly, in 2011, the Commonwealth realms decide that they will alter the rules of succession to end male primogeniture and to liberate royal marriages to allow Catholics, or allowed marriage to Catholics. All other states agree, and we get moving. Australia and New Zealand change their own laws because they have their own crowns and they are fully independent states. Canada does not. Canada, contrary to the Abdication Act of 1936, simply says we are assenting to the British law, the British will legislate this issue, and we don't need to concern ourselves with it. All we have to do is agree. Now this raises a question, well, how does the UK legislate for us now, since it can no longer legislate for us now since 1982? Well, how do we get around this? We get around this by saying that the preamble, once again the preamble, we are still under the Crown of the United Kingdom of Great Britain and Ireland, is the basic federal case. Now other cases have been made. Again, going back to Walters, Walters argues it's not a question of anything else, it's simply a part of our Constitution. It's not a matter of the architecture. But the federal argument goes explicitly to the ruling in O'Donoghue and says we are under the British Crown, it's the same Queen, there is no difference between the Queen of Canada and the Queen of the United Kingdom, therefore whatever they decide is automatically the case for us. It is currently being challenged in Quebec courts. But it's interesting that effectively we are claiming that we are less independent than Australia, less of an independent state than New Zealand, simply because we forgot to make some changes in the 1970s. So where does that leave us today? Here is my basic interpretation. The nature of the Crown of Canada. The monarch remains our head of state. The Crown remains the legal personality of the executive. However, it appears, if we're to read the rulings, that it's a British queen, but a Canadian corporation. So effectively, we have at the head of our state a British person. They're Canadian corporations, but with a British queen at the head of it, which tends to suggest that maybe it is finally, in Canada, a corporation aggregate. So the Crowns in Canada may be a corporation aggregate with a British Queen at the head of it. It doesn't mean the Canadian state is necessarily British, but the person that heads our state is British. Does this mean, therefore, that we are still fundamentally united under the Crown of the United Kingdom? Have we not retained our independence? Equally interesting, are we seeing effectively a conflation of the executive and the state in Canada, where Her Majesty and Right of Canada is meant to represent the state, but is now effectively being reduced merely to the executive power? So, to conclude, where is the drift? It has not, the judicial interpretations of the monarchy and of the Crown have failed to keep pace with the patriarchy and the Constitution. And I'm not necessarily, although I disagree with this, I'm not necessarily saying they're wrong. They simply have not updated their understanding to keep pace with the change that occurred in 1982. And getting back to the interpretive approach, it may simply be that they no longer accept that the Crown is the concept of the state, and therefore they have no difficulty not adjusting or adapting. So the monarch is now narrowed down to the head of state, as was recommended by the Law Reform Commission, and the Crown has been narrowed down to an executive personality alone. The source of sovereign authority in Canada and the personification of the state, unfortunately, remains British. So this is contrary to the Crown up to 1982, and it's contrary to the notion of the Canadian Crown that we find in British jurisprudence. And I'll end on this. It will be very interesting if the royal succession case comes down and declares that it is a British Queen in Canada. Does that allow First Nations to once again, in Canadian courts, claim that that the British Crown has treaty obligations towards them, even though British courts said they didn't? Are we going to have two different understandings of the nature of the Crown in the UK jurisprudence and in Canada, and what does that mean for suing the British Crown in Canadian courts? And I'll end with a fun image.
We have a little while left for questions. As people have questions, please come up to the microphone in the middle. And at the RGCS lectures, the first question is always reserved for a member of the RGCS Student Fellowship.
Hi. Is this on? Okay. Sorry, I'm not a particularly, I don't know a whole lot about law, but I guess my question would be, if it's a British person on the throne, what would happen if some horrible event happened and all the British claimants to the throne were somehow wiped out and there were only non-British claimants left? Wouldn't that create an issue for your theory of who the physical person on the, like what if there was only a Canadian claimant left?
It's an interesting question. Luckily, there's thousands of people in the line of succession. You can't really get rid of them. What is interesting, however, is, and this is a discussion that we were having earlier, the reason this becomes quite pertinent is what happens if the UK becomes a republic. If you follow the federal government's reasoning, if they simply choose to get rid of the monarchy, that means we no longer have a queen, and it means our entire constitutional structure has to be rethought, or you have to devise a very clever way of getting around that problem. So in a recent book chapter with Patrick Baud and I have given a partial answer, which would be you could technically, to your point, change the law to make the Governor General the personification of the Queen. Because if you follow what was said in McKeeter 2, if the Queen is merely a symbol, and if it's totally now divorced from the natural person in the UK, then you can make anybody the Queen. And if you follow the government's reasoning that the Queen's identity is not a matter of paragraph 41A, well, then you can do that without even consulting the provinces. Because the federal government is arguing that succession is not a matter of the office of the Queen. That who gets to hold the office has nothing to do with the office. Therefore, that leaves open quite a bit of possibility if ever the British monarchy simply disappears for whatever reason, the Canadian government will either have to be really creative or find some other way around it, right? Or simply declare the office hollow. That's another thing that they could do. You could technically declare that the office of Queen is vacant, and therefore that the Governor General, through the latest patent, can exercise all her powers. That's another way of doing it. It would leave you with a number of possibilities, but it would effectively mean that the highest office of your state is not occupied by any office holder, and that the Governors General would be reappointing or appointing their successors with no check. Because there is actually a check now in the Constitution that the Queen is the one that technically appoints Governors General. She's also required to sign off on appointing additional senators. So you would effectively eliminate those two checks in the system. Some people don't think it's a big deal, but it would probably be fairly significant. But yeah, it would leave us, is there a possibility, and this did occur during the Second World War in Hungary, where you effectively declare the crown vacant, and it still performs all its functions, but it basically has no person attached to it. And that seems to be what Wheeler was getting at in McKeeter. You could easily do that.
Thank you. I just have a quick question. Why is this specifically to do with the judicial developments in relation to the Crown as opposed to a failure of the legislative bodies to enact law to do with this question?
Very good point. I think I mentioned it a few times. Those that ultimately drafted the Constitution Act of 1982 could have made a better effort to include all these imperial legislation, but they didn't. Ultimately, Trudeau's focus leading up to 1982 was to change the office of the Queen, to make it effectively the Queen would be not even head of state. The Queen would simply be, if memory serves, the Queen would be head of state, but the Governor General would be first Canadian. And so there was actually an effort to simply retain the current structure without everything else that was done on the legislative level. So I fully agree with you. It's not simply the courts, and I wouldn't even use fault. But what's interesting about it is that the courts in with the Alberta Indians case get a clear indication of where they can go to get around this, and yet have never kind of followed suit. And given paragraph 41A, legislatures don't want to touch the office of the Queen at all now, let alone the monarchy generally. So it kind of falls on the courts, I would argue, to interpret this institution. They're the only ones that really encounter it on a regular basis. And without being accusatory, I just find it fascinating that they retain the idea that this is still a British institution. And so I'm not trying to say it's their fault, but in terms of institutional change that they're bringing about, they are the main actors, really, since 1982, because they're the only ones that really interact with them, aside from trying to deal with certain types of prerogatives. Yeah.
So I don't know if I'm repeating the same question, but I'm wondering if you're not taking what the judges say too seriously, because clearly as you know my opinion of the two judgments in the McKeeter litigation, I don't think they knew what they were talking about, not just the Crown. You have said yourself in the O'Donoghue case, I think that the Teskey case was also a very weak judgment. Mm-hmm. And so it's not those things. I didn't learn them in law school. It doesn't look like the judges in those cases learned those things in law school either, or anywhere else. Why take what they say seriously at all?
Okay, no, it's an excellent question. I would tend to agree, except when the following things happen. As in the royal succession case, O'Donoghue is this wild theory of constitutional interpretation in Canada, drawing things left, right, and center with no sense of direction. And yet O'Donoghue ultimately then becomes the basis, I would argue, of the federal government's defense of the Succession Act in 2013. So it does kind of matter in that sense, that O'Donoghue lays down this idea of a principle of symmetry, or a notion of symmetry. Now that we're in the world of constitutional architecture, when you start throwing and bandying terms like principle and symmetry and all these other things around, even a judge that kind of makes a flippant remark about these things can ultimately end up having quite a significant impact. And the reason I take McKeeter seriously was because of that interaction between Morgan and Wheeler, where Morgan is actually making a pretty good defense of the Crown in Canada, what it actually means. And then Wheeler comes in and effectively has, for all intents and purposes, given the greatest victory to republicanism in Canada, I think, that I've seen in a long time. A judge just kind of comes in and declares, the Queen has no meaning. As one of my people, somebody I interact with on Twitter often says, you can just have the Queen as a stuffed beaver. And if you follow the reasoning now, McKeeter, this is the Queen now. It's just with the teeth, and you just leave that up. And, well, there it is, because it's a Potemkin monarchy now. So although I agree that it's kind of a specious ruling and it has very little content, the impact that it might have in the future as to how you get around the office of the Queen, if the office of the Queen actually doesn't mean anything and it's not connected in any meaningful sense to a person, then you could have an empty office, right? And that's not insignificant for how you might get around that office in the future. So in a sense, I agree with you that they probably weren't taught this, and clearly their clerks weren't taught this. But that's a bad thing. we should be critical of that, I think.
Okay, so my question is the following. So here's a whole line of cases that I've never heard of about the Crown, where the courts are dealing with this concept, and obviously there's a lot of confusion there, as you've laid out. And yet all of these cases that I'm familiar with on the Section 35 jurisprudence is that the honor of the Crown, right, it's all about the honor of the Crown. And more, the Supreme Court at least is hanging real important obligations on governments because of the honor of this Crown, which on the other hand they're saying is meaningless. So I'm having real cognitive dissonance here. So either just tell me that's just what it is, right?
Yep.
That there is massive cognitive dissonance here, or is there actually a way of
Yeah, no, that's fair.
how can the court at one hand talk about the honor of the Crown as putting really important obligations with respect to Indigenous peoples in the country, and then at the other say the Crown is meaningless?
It gets down to definitions. So I think one of the best things that somebody in law school can do, or somebody studying the Crown can do, is just go and pick up a copy of Paul Lorden's edited volume, Crown Law, from 1991. Okay, Department of Justice issued book. And what's interesting there is most of the time what the courts do when they talk about the Crown is they define the Crown as government as opposed to the state. And so when they're talking about the honor of the Crown, what I'm hearing is they just mean government. Right? They mean public authority. They mean the executive, or they mean potentially the Crown. But you're right. This is where it gets problematic, right? Because from a First Nations point of view, it's not. If it's just the government, that wasn't the deal, right? It's supposed to be equal sovereignty on some level, or at least a nation to nation. So therefore, the Crown as the concept of the state actually matters a great deal. And when I was first kind of ruminating this paper and trying to put it together, I was looking at different theories of institutional change. And I'll tell you a little bit what I didn't say in the paper. Drift is usually associated with what Mahoney and Phelan called parasitic institutional change. Parasitic institutional change is basically when an actor will change the meaning of an institution in any way possible because it suits their interests to do so, their private interests. And they put the emphasis on private interests, which I think is wrong. I think the courts are simply making the Crown be whatever it happens or needs to be whenever it suits their interests. They don't care if they're destroying the meaning of the institution. They don't think about it. They probably don't have much respect for it to begin with. I mean, to be blunt, I don't think they put much meaning into it. And that's why that reference by McLaughlin, she doesn't even consider the Queen, at least at the time of the ruling, to be part of the Crown. So it's not insignificant. But if I were to kind of boil it down to the essentials, what we're seeing here in terms of the interaction with the courts, and I have a colleague of mine in machinery of government in Ottawa who argues with me about this all the time, and he says it's the virtue of the Crown that it basically can mean anything. Really? But if it can mean anything, then it means nothing, right? Then it has no meaning. And to your point, then it can be used for whatever purposes. And I do think it's a concern if we can't even attach anything. So honor of the crown, honor to who? Honor to what? Who's honoring? If we simply mean government, then maybe that's not exactly what First Nations have in mind. So I agree with you, it is a problem.
Hi. It seems to me like we have, you went through the rulings, that we have all these people kind of telling the Queen what she is, right? Or defining what the crown is.
Yep.
But has anyone asked the Queen how she sees herself? Or like how does the Queen define her own role? Like do we have any commentary on that? Or, like what is she doing? She must be, confused as to what exactly she's supposed to be doing. So I don't know if you have any answers to that.
I can only provide anecdotes, but they're good anecdotes. In all seriousness, no. One book that is illuminating, I should say, is a book by Philip Murphy called The Monarchy and the Commonwealth, and it's his historian's work, and he looks at how the Queen actually was deeply involved in decolonization in the UK. And we tend to think that she was a marginal figure, and she was actually personally involved in a number of the decisions and putting pressure on numerous actors. So she actually does care deeply about these things. She's just not allowed to talk about it. But as we saw, everybody is always ensuring us that the Queen has no opinions, none whatsoever, and will never say anything controversial. And then suddenly she'll have an offside remark during the Scottish referendum. She has opinions, and she believes in these things quite significantly. To be blunt, I think the British monarchy actually does a terrible job at explaining this, though. So in our age, and I'll use yesterday as a good example. So yesterday, our Prime Minister met with the Queen, and he had a private audience with the Queen. And we know, therefore, that he was meeting the Queen of Canada because Prime Ministers are only given private audiences. You don't have a private audience for a foreign dignitary. So we therefore know, procedurally, or in terms of protocol, that he was meeting the Queen of Canada, not the Queen of the United Kingdom. Because otherwise he'd be meeting a foreign head of state, in principle. Although we may not be right about that. So anyway, this was an interesting moment. And yet, who tweets pictures about a meeting between the Prime Minister of Canada and the Queen of Canada? A Twitter account called British Monarchy, run by by Buckingham Palace. Similarly, if you want to find out any information about the Queen's role in Canada, you have to go to a website called the British Monarchy. And on the British Monarchy, the British Monarchy site explains that she has a fully independent role in Canada and this, that, and the other thing, but her entire people around her are making no effort, if I can be blunt, to actually Canadianize this office in a meaningful sense in this day and age. Right? Rideau Hall also doesn't really make much of an effort because they know how controversial this issue is. And the federal government is contradictory. So we get a citizenship guide under the Conservatives that really emphasizes the fact that Canada is a monarchy. Canada, the Queen of Canada is separate and distinct. It's the Canadian Queen. She is fully Canadian. And then she is participating in Canadian events. But then the minute that that notion is challenged, they jettison it and say it's a British monarch. So to answer your question, what does the Queen think? We don't know. But she probably is not overly concerned with it, because her bigger problem in a Canadian case, if the Canadian government turns out to be correct, is she'll have to be more worried about being thrown out in the UK than anything that might happen in Canada. Because it would basically mean that you need unanimity to get rid of the concept of the Crown in Canada, and the fastest way to get rid of the monarchy in Canada, therefore, is to get rid of it in the UK. So she would be far more concerned with that. I mean, it's kind of ironic in a sense that the easiest way to change, or to this is really ironic. I'm going to pause and restate it just because it's delicious. If you're a Republican in Canada now, the best way to ensure that you sever ties to the British monarchy is to actually ask the UK to do it. So you're basically still acting like a colonial dependency. It's quite fun.
Thank you. I wonder maybe if I can push back on a comment you made just a minute ago a little bit about the court not knowing or not caring. I mean, I think in the end they would care very much because there's a very real sense that, when Elizabeth dies, Charles is put in the Tower of London, and William's declared the king or crowned the king. One can only hope, right? That the Canadian people will accept him as the King of Canada, and there won't be this, they won't need a judge to come out and tell them that that's the case, right? So I feel like there's a sense of, if there's ambiguity and confusion here, it's because they're trying to deal with this mistake in the law, or this, this hiccup, if you want to call it, combined with the fact that there is a real sense among Canadians that that is the case, that the person on that throne is their monarch. And so I just wonder your thought on that.
Yeah, I'm probably being a bit disingenuous. I suppose it's simply a frustration on my part when my whole kind of interest in this particular aspect really began from the fact that I was interacting with the succession case legislation. And when you went through the jurisprudence and you went through the history, and it really seemed like this was self-evident, that it's a Canadian crown, it's a Canadian corporation, that it's the Canadian state. How could we have not gotten here? And then you suddenly discover that, as far as I can tell, the Canadian judges just don't even really refer to the Alberta Indians case when they're talking about the crown. And it's just stunning to see that it's not even referred to. Similarly, even as late as 1978, in PEI, in a case of PEI, I think, versus New Brunswick, or PEI versus Government of Canada, actually, the judges are still debating whether or not the provinces are actually separate entities from the federal government in law. They're not really, they're saying, well, we could say that the Queen has legal personality separate in PEI than the federal government, but it's just easier just to say that politically they're separate. We're not going to deal with it. So it's constant frustration on my part of seeing a judiciary that doesn't seem to be wanting to interact with this concept in a meaningful way to give it some kind of coherence. And again, maybe that's its virtue. Maybe the whole purpose here is that the judges don't want to say more than they have to, right? On the other hand, there's no reason, for instance, in El Dorado that you can't have a judge say it's the Queen of Canada. There's no reason why they can't say these things. So that I find a little bit a source of frustration. And then just a funny anecdote. Around 2012, one of your colleagues in the Faculty of Law, I won't say who because I don't remember who it is, but I wouldn't say it anyway, wrote and said, hey, do you think there's enough material to teach a course about the Crown in Canada? And I just wanted to cry. I'm like, of course there's enough material. It's the concept of the state. It goes back 1,000 years, but it's like such a minor thing, right? It seems to be in the law schools. Like, it just seems to be so marginal that I'm probably being unfair because, again, I did say Edward Morgan, who was a law prof at U of T, has probably the most coherent statement about the nature of the Crown in Canada. But all the other rulings really seem to be loosey-goosey, if I can be nice.
Hi, I was just wondering how you foresee constitutionally and politically the eventual succession happening. Sometime in the hopefully not too near future, but how you foresee that happening.
Okay, good questions. I'll address it in two parts. The first part is the great thing about the Crown as a corporation sole means that succession is automatic. Hence, that's where we get the expression, the king is dead, long live the king. Because it is always an undying same person, the minute the Queen dies, Charles automatically becomes king, and all laws that refer to Her Majesty in Canada automatically apply to Charles. There is no problem. The part of the reason that the Crown was made a corporation sole was to deal with the problem of succession. It was simply to get rid of that issue. So automatically, Charles becomes King of Canada, and there's no need to do anything. Canada has made sure that when there's a demise of the Crown, we don't have to recall Parliament. The laws that are in place or making their way through the Parliament stay in place, so on and so forth. So on a practical level, doesn't mean anything. Where it does get interesting is regency. Okay? So in principle, even those who agree with the federal government about succession and abdication do not agree that there would be an automatic recognition of regency. So if the UK declared or passed a law saying that Charles is the regent of Queen Elizabeth, it would not apply in Canada. Now, even people who support the government's case on succession agree with that. So this creates a bit of a quandary. What do we do in that case? Well, it's probably not a big deal because the letters patent 1947 do allow the Governor General to exercise any of the Queen's powers. So in principle, the argument has been made that the Governor General would effectively be a regent for all intents and purposes. Okay? But then the question I pose is, doesn't that therefore mean that the Governor General is already regent. If that's the case, then why not simply declare the Governor General regent and have the Governor General appoint his or her successor? Because those that make that argument that the letters patent allow that have no good reason why the sovereign should currently be appointing the Governor General. If you simply want to exclude the Queen altogether from the Constitution, regency is the way to go. You just make the Governor General regent, and you never have to deal with the Queen again in Canada. Now, again, this would create problems for the naming of additional senators. However, you could even make the case that the Governor General could simply appoint additional senators. I don't think that was the purpose of the law. I don't think that's the purpose of the Constitution. It was a two-key system, but if you're really looking to get creative. But just so a simple answer on regency, it would effectively not allow us to, or not allow a Prime Minister to name additional senators for however long it takes for the British monarch to die. So it would create some problems. That would be the only real practical problem.
Last question.
So you mentioned Australia and New Zealand in your presentation, but I'm just wondering if there's any other British Dominions or former British Dominions that are in kind of a similar situation, or even if there's any other nations that have a similar complex relationship with their former colonial head of state. Is Canada alone in this, or can we learn any lessons from elsewhere?
Well, this is what is somewhat interesting, is effectively the federal argument is that we are constitutionally of the same order as, let's say, Jamaica or Papua New Guinea, as opposed to Australia and New Zealand. So they fully recognize that the Queen of the UK is their queen. They don't even really have to deal with it. I think it's Papua New Guinea in particular that explicitly recognizes it, that whoever is monarch in the UK is their monarch, and therefore they get around the problem altogether. But they're pretty unabashed in saying that, right? There's no question. The lesson you can learn, therefore, is that constitutionally we're more the equivalent of some of these smaller islands than we are of Australia and New Zealand, which may be fine, you know. I mean, but it seems to go against what we declared in 1982. And I'll just end on this. While researching this, you have Pierre Trudeau on Parliament Hill in 1982. The Queen is right next to him, and he declares very boldly that we are now fully sovereign and independent. Is he saying that in the presence of the British Queen? Or is he saying that who just signed the Constitution for the Royal Proclamation of the Constitution of Canada? Or is he saying it with the British Queen next to him issuing a proclamation for a fully independent Canada? My sense is he probably thought it was the Canadian Queen, but apparently not.
This concludes the RGCS lecture series for this semester. We will be back in this room, I believe, on February 6th for Janet Bednar on federalism, and then on April 30th for the debate on the nature of property and ownership. I also want to mention that the Jan P. Lind Center, of which RGCS is a part, will have its inaugural event on April 13th in the Faculty Club, when the Harvard sociologist Orlando Patterson will give a public lecture. There are other smaller events associated with both RGCS and the Lind Center that will be happening in between those big public events, and those are available online. And I hope that you'll join us for a little while for a reception in the adjoining room, and let's thank Philippe Lagassé.